Good afternoon, ladies and gentlemen, and welcome to Mullis and Peake's Mock Employment Tribunal. Thank you all for being here today. My name is Manzoor Islam, and I'm associate in the firm and head of the Commercial and Employment Litigation team. Now, because we are about to start the Employment Tribunal proceedings, we will all have to stand. So I could ask the tribunal room to all please rise as employment judge enters.
So effectively there are two claims here, unfair dismissal and notice pay. And there's nothing else that's being brought or any other applications in that regard?
No.
Very well. Well, I know the government have been trying to make tribunals as cheap as possible, but I do think, given the public gallery and given the public interest in this case, I'm going to go against the usual form and let's have witness statements read out. And it may be useful as well, if you consider it, to get your clients to read any emails that are relevant to their evidence in case the members of the public don't actually have the copies of those emails.
I'm grateful for your education.
So my client's an MP. Can I just check that he can read? Yes, that's fine. Thank you, sir.
Humour is not allowed in my tribunal, Mr. Holloway.
No, I remember, sir.
Very well.
I'll call the witness for the claimant then. That's
Very well.
The claimant himself. It's Mr. Ian Fulmer. Thank you.
I was employed as constituency office manager for Mr. Seat between the 1st of May 1997 and the date of my dismissal on the 13th of February 2015. Part of my role involves processing the office expenses. When I came to complete the records for January, I was surprised to see that the expenses claim for the 15th of January included a bill for a suite at Claridge's costing over £1,000. Mr. Seat was away on a fact-finding trip in Italy at the time, so I couldn't ask him about it. Before he returned from the trip, I bumped into Tanya Tail, the constituency manager at Bootlethwaite, the neighbouring constituency. Over a drink, she happened to mention that her MP, Iona Duckhouse, had also been at the Moat Builders reception and then had stayed an extra night, claiming that she had a further meeting, that Miss Tail's cousin is a doorman at Claridge's and had told her that she'd been there with a man and had left his room at 4 a.m. At this point, I put two and two together and realised that Mr. Seat and Ms. Duckhouse had been together.
This is ridiculous!
I knew that they had not been there on official business, as Ms. Duckhouse is a member of the Independents for East Yorkshire Party, and they refused to have any dealings with the Unity Party. It also made sense as to why Mr. Seat had been excluding me from constituency matters. I was shocked and outraged by Mr. Seat's actions. What he gets up to in his private life is a matter for him, but to try and claim for the room on his expenses was clearly fraudulent, and I felt I had to act quickly. I firmly believe that the reason why I was dismissed was because I made a protected disclosure, and I also believe that the procedure used to dismiss me was flawed, and I had no chance of a fair hearing. And I believe the contents of this statement are true.
Thank you, Mr. Fulmer. If you wait there'll be some further questions for you.
Mr. Fulmer, I'd just like to begin by understanding the precise reasons that you give for you say suspecting Mr. Seat of fraudulent activity. During your 18 years in the role for my client, you would have been involved in the seismic events of 2009, where we all remember the expenses scandal and the way that played out.
That's right.
And as a result, what probably the most significant change that came out, other than a lot of people losing their jobs, of the scandal was the introduction and the establishment of the IPSA, the Independent Parliamentary Standards Authority.
Yes.
And that was a body that was responsible for policing expenses, but also receiving expenses submissions. And that's a body that you were in regular contact with in that context. Yes. Thank you very much. That was by way of background in the context of expenses. Let's move on again by way of background to Iona Duckhouse MP. In the climate that you describe at paragraph 7 of your witness statement, where there is effectively, should we look at it? I see you turning to it.
Yes, I've got it.
Let me be fair about it. What you say is, At this point, I put two and two together and realised that Mr. Seat and Miss Duckhouse had been together. And then you say, I knew that there had not been there on official business, as Miss Duckhouse is a member of the Independents for East Yorkshire Party, and they refused to have any dealings with the Unity Party.
Yes.
And now the point here is that in the event that there was some crossover and requirement for those two MPs to meet, that would need to be done in a somewhat clandestine way. Would you accept that?
Up to a point, because over the years, you will have noted also that I regarded myself as my employer's right-hand man, and so that I knew that there hadn't been that sort of liaison historically.
Yes, but the reason for the somewhat strained relationship that you've been enjoying, although that's not quite the right word, with my client since the early part of 2015 is in fact because it seemed to my client that you had taken something of a liking romantically to his wife. Do you accept that?
No.
Very wise. Did you give him? Did you give her diamond earrings for Christmas?
Well, no, actually, I didn't. They were sadly they way out of my salary range. They were glass imitation. They were just a little gift. It was just a little thank you.
All right. Okay. In the email, you say this. I have information which shows that the MP for Halton Price Ivor Seat has been conducting an affair with Iona Duckhouse MP. And so that's based on the one occasion.
And the rather strange behaviour I've described to you over a period before that occasion.
All right. And you go on to say, in particular, they have been meeting at hotels and then attempting to claim the costs of their liaisons as MP expenses. So you are making it crystal clear there that you are saying that this is something that has happened on multiple occasions.
Yes, well, I assumed it must have been in view of the way he'd been behaving.
But you had no reason, no evidence at all for believing, even if it happened once, that it had ever happened on any other occasion.
The only hard evidence I had was that £1,000 claim, yes.
Okay. All right. So the first thing that you did to speed up the process is set up a new Gmail account, informer@gmail, which I assume you didn't have already.
No, this is my normal.
That's your
account.
normal?
It is, yes.
Okay. Is it a hobby for you?
Yes. No, yes, I have one or two.
Lovely. But rather than contacting the body that you were in regular communication with, who you would have known people at to raise this complaint with, you instead searched out a tabloid newspaper and sent them the disclosure.
No,
is that your evidence?
I have to admit I was upset and angry, and that's the way I felt it needs to be dealt with.
I'm conscious of time, so I will trot through the rest of things quickly. A vital part of your job was that you could be trusted with confidential information.
Indeed.
I know that what you say is the information that you provided amounted to a public disclosure
Indeed.
for which you benefit with protection. But if you set that to one side for a moment, do you accept that disclosing the information you did was a breach of confidence?
Yes, I do.
Thank you. And
But I felt it was in the public interest, that's the point.
yes, that's fine. And the tribunal will decide whether or not you're right about that.
So.
Okay, thank you very much indeed. I don't have any other questions.
You can go back
Thank
to
you.
your
Thank you.
thing.
I close the claimant's case.
Great.
Yes, thank you very much, sir. Well, in that case, I'll call my one and only witness, the respondent, Mr. Seat.
Ivor Seat of 37 Coalition Drive, Halton Price, East Yorkshire, will say as follows. We worked well together for a number of years, but things began to change when I married my wife, Doris, in 2013. Doris is an active local party member, and both Claimant and I had known her for a number of years. I gained the impression that the Claimant held a bit of a candle for Doris. Matters came to a head over Christmas 2014, when the Claimant bought Doris some diamond earrings as a gift. We both felt this was completely over the top and decided that we ought to try and deal with the Claimant on a more professional footing. As a result, I tried to only discuss work matters and refrained from inviting him to our house, as I had done in the past. I love you too, Doris. Unfortunately,
Love is welcome in this tribunal. I don't object to that.
Really? Unfortunately, the claimant did not react well to our attempts to distance ourselves, and his attitude changed. He began to question my decisions on a number of occasions, changed things in my diary without consulting me first. As a result, I started to do more things myself, as I did not want the trouble of being quizzed by the claimant. One particular instance was a meeting I had scheduled on the 15th of January 2015. I was due to meet with Iona Daghouse, the neighbouring MP. We had received some information that a large local factory was going to be sold, which could have led to significant job losses in both of our constituencies. Following the meeting, I went away on parliamentary business. While I was away, I was contacted by a journalist from a speculator who asked me if I would like to comment on a story they were running about my involvement with a certain opposition MP. I obviously wanted to know where this information came from, as I was concerned about my confidentiality. When I got back to the office, I decided to look into Claimant's email account, and in the sent messages folder, I found an email to the speculator making allegations that I was having an affair with Iona Daghouse. I also found a number of other emails to the claimant's brother, where he regularly discussed matters relating to my diary. I considered that the emails revealed that the claimant had breached the strict duty of confidentiality required by his role, and I therefore invited him to a disciplinary meeting and informed him that he was charged with gross misconduct. I strongly dispute there had been fraudulently claiming expenses, and I had dismissed the claimant from making a protective disclosure. I believe the contents of this statement are true.
Thank you very much indeed. If you wait there, there'll be some more questions for you.
Thank you, Mr. Seat. Now, as a Member of Parliament, you've been a Member of Parliament for 18 years, haven't you?
I have, yeah.
And you're fully aware that as an MP, you are expected to observe the highest standards of honesty and probity.
Absolutely.
And the claimant, Mr. Former, he's your constituency officer manager. And in that role, one of his jobs is to manage your diary, isn't it?
Well, he was my manager, yes, and that's one of his roles.
And therefore, he could reasonably be expected to know about your professional engagements as an MP.
That's true, yeah.
Yeah. And another part of his role is, of course, to process all office expenses.
Yes. Yeah.
Right. You then went to the UK Moot Builders Association meeting, and you then had a meeting with Iona Daghouse on the Thursday, and you had that
true.
at Claridge's, didn't you?
Yeah, absolutely, yeah.
You booked a suite, which you admit.
Yeah.
You admit that it cost £1,000.
Give or take, I think it's a bit more than that, yes.
You had a London flat at your disposal. You were staying there because you were having an affair with her, weren't you?
No, that's not true at all. I've never had an affair. I did have a meeting with a fellow MP. I did rent a suite in Claridge's, and it did cost that much, but everything in London costs that much.
You never made available to my client the actual emails that you were concerned about, did you? Because you invited him to a disciplinary hearing without sending him the particular copies of the emails that you were talking about. Without revealing those emails, the tribunal has no way of distinguishing between ordinary emails about professional public engagements that are in the public domain and what you say are highly confidential, security-sensitive meetings.
Well, Counsel, I'm sure I'll have a word with my solicitor who should have prepared those emails in the first place.
It's a matter of basic fairness, though, isn't it? If you're going to take disciplinary action against somebody, that you give them advance warning of the material that you're relying upon so they know what they're answering.
As I said to you before, I'll have a word with my solicitor, who I'm sure has got the printouts of them somewhere on file, and I apologise on his behalf.
Well, it's not a matter for you, unless there's an application for a postponement, and which I don't see forthcoming. We will have to deal with the evidence that we have.
Yes, thank you. At the disciplinary hearing, did you produce the copies of the relevant emails?
No, I did not.
No. So he's, in fact, other than the very general allegation of breach of confidentiality by my client, that's essentially all he's ever had, isn't it? He's never had particulars, evidence, documents, and essentially you found him guilty of breach of confidentiality, but actually we've no idea what precise thing you found him guilty of, because you can't produce the emails. You just simply refer to emails disclosing details of private meetings, but we just take your word for it. The real reason you dismissed my client was because he whistle-blew on you, isn't it? It's got nothing to do with breach of confidence.
Well, no, I completely disagree with that statement.
Thank you.
Anything in re-examination?
No, sir, there's no re-examination.
Go for it.
Thank you.
I have nothing further. So we will rise now to make our decision, and the clerk will come and get you. Don't go too far. I'm sure the clerk will come and get you pretty soon.
All rise. Now is the opportunity. Well, now the tribunal panel will be going away to deliberate on their decision. It's all right, you don't have to stand for me. So they will be going through their notes, looking at the evidence, considering what the parties have said this afternoon, and then they'll reach a decision based upon the legal guidelines which the respective counsel have set out. So now is also the opportunity for you all here to make your own decision. You should have within your pack a voting form. Keep it just as claimant and respondent. If you think the claimant's been unfairly dismissed, tick the box for the claimant. If you think the respondent has fairly dismissed, tick the box for the respondent. I actually wanted to do red tomatoes and green peppers, but no one listens to me. Got the votes, the audience votes back. The figures are, for the respondent, 15 votes. For the claimant, 31. So in election terms, it's something of a landslide. But as I mentioned before, it doesn't count. So you can still lose.
The people vote.
Well, at least we got 15.
I think that's about right. I think I would have taken that at the beginning.
But it will be interesting, genuinely interesting, to see whether the tribunal actually agree with that.
I note the somewhat late hour, so that the way I propose to do this is we will send a full reasoned judgment in the post. But I will, don't worry, I will give a judgment now, but it won't be quite as thorough as you might expect in a case like this. I agree with Mr. Holloway's submissions that under 43GB, for example, there simply wasn't enough evidence for the claimant in these circumstances to believe that the allegations, which effectively in this case amount to a criminal offence, were substantially true. I disagree, however, that he did it for personal gain. Consequently, this was not a protected disclosure, and consequently the case of automatic unfair dismissal fails. What are we then left with? An ordinary unfair dismissal claim. And standing back, what we have here is an employee who has not in fact made a protected disclosure and has gone to the press with information, with suspicions, no doubt harming his employer, breaching confidence. As he admitted in cross-examination, he breached confidence, and indeed the principle of simply disclosing emails to somebody outside the organisation is also a breach of confidence. It's a job which requires a great deal of trust, as was admitted in cross-examination. And of course, it is not for the tribunal to substitute its own views. But given all of the facts and evidence, we do not find that these procedural failings were sufficient to render the dismissal unfair, and therefore the claims are dismissed.
Thank you, everyone, today. What the tribunal perhaps aren't aware of is actually the audience voted as well today. They voted overwhelmingly in favour of the claimant.
Oh, we heard, actually.
So it's... can't keep anything secret. I hope you enjoyed the afternoon's events, and we hope to see you all again soon. And don't forget to leave your feedback forms on your way out.